Assalamualaikum warahmatullahi ta'ala wabarakatuh. For the subject Administration of Islamic Law in Malaysia, I would like to begin our group presentation. My name is Muhammad Syafiq Akmal and I representing on my group. For your information, our group consists of 5 members, namely first, Luqman Nur Hakim, Muhammad Nakib Salam, Muhammad Haziq bin Jeffrey and Muhammad Hafizullah. Today we will be presenting an important case entitled Suji T.O. case. T.O. and Huwat versus Qadi of Pasimah, Kelantan and the Kelantan Islamic Religious Council 1986, which closely related to the administration of Islamic law in Malaysia. As the first presenter, I will begin to the introduction of the case. Fact of the case: an important case concerning freedom of religion for a minor. Suji T.O., 70 years old, raised as a Buddhist. She left home and subsequently pronounced the Shahada before the Qadi of Pasimas. The Qadi confirmed her conversation without informal or obtaining consent from her father. Her father, T.O. and Lau, applied to the court for a declaration that a minor does not have the legal capacity to convert religions on their own, and only the Qadi acted ultra virus but obtaining the guardian consent. The case garnered attention because it involved the constitutional right of a minor, the extent of the authority, religion official, and the jurisdictional boundaries between the civil and Shariah court. Thank you.
After that, I want to talk about legal issues. Issues 1. Does a minor under the age of 18 have the legal capacity to convert religion without the consent of his or her parents? Second issue, did the Qadi of Pasimas act beyond his powers ultra vires by accepting a religious conversion without the consent of the father? Third issue, does the civil court have jurisdiction to conduct judicial review over the administrative action of religious authorities? At the time, 1900 of 86, Article 100 of 21 1A was not yet enforced. Thank you.
Relevant law and legal provision. Federal Constitution Art 11 in bracket 1, the right of every person to profess and practice his or her religion. Raise the question of whether this right include minor Art 12 in bracket 4, the religion of a person under the age of 18 is determined by his or her parent or guardian. Art 121 in bracket 1A, after 1988, civil court shall not interfere in matter within the jurisdiction of the Shariah court, not applicable to this case. Kelantan Islamic Administration Law. The Qadi is given the authority to receive, verify and register conversion of religion. There is no clear provision requiring parental consent for minor. Legal principle apply. Freedom of religion belongs to an individual who understands his or her action and is not determined solely by age. Civil court may review administrative action that affect fundamental right. Parental rights are not absolute in determining a child's religion.
Court's decisions. For the court's decision, this case was decided by the High Court of Kuala Lumpur. The court rejected the father's application, which challenged his daughter Suzi's conversion to Islam. The court made several important things. First, a minor may choose their own religion if they are mature enough to understand the meaning and consequences of their decision. Second, the judge did not act beyond his powers because Suzi converted to Islam voluntarily. without any coercion. Third, freedom of religion is an individual right, and it is not an exclusive right of parents. Therefore, the father's wish to control his child's religion until the age of 18 was found to be inconsistent with the spirit of the Constitution. In conclusion, Susie's religious conversion was held to be valid and effective.
The case illustrates a clash between civil law, Shariah law, and constitutional rights. It highlights that issue become more complex when minors are involved. It raised the question, should age or maturity determine one's choice of religion? It demonstrates the need for clearer procedure in case involving the conversion of minor. The court's decisions influence national discussion on parental rights and responsibilities. The case was later overruled in 1990, evidence that the law is constantly evolving. It raised awareness of the importance of justice, transparency, and sensitivity in matter involving religion, family, and constitutional rights.